Hi everyone, welcome to the webinar by Octopus Law School on a very interesting topic, dealing with the practicalities of check bounce. I have never had my check bounce, or I've never had a client, but it's a serious topic. It's something which is highly practical, highly useful to you. Hi everyone, hi again. I can see a lot of people joining in. My name is Tanuj Kalia and I'm the founder of Octopus. With me is Samiksha. Samiksha is one of the best young criminal litigators I know of. She is a graduate of HNLU Raipur. She has worked with the best of the best. She has worked with the likes of Mr. Satish Maneshande, who, Samiksha, I'm guessing, was Shah Rukh Khan's lawyer. Is that accurate?
Shah Rukh Khan, Riya Chakrabarti, Sanjay Dutt.
Okay, awesome. So very high profile clients. I'm not going to ask Samiksha on whether she has met them or not. Awesome. But welcome everyone. I can see a lot of people joining in. I'm going to allow us a couple of minutes to let everyone who wants to join in, join in. So folks, what I would request is on the chat box, please drop in quick introductions. Okay, choose the host and panelist option. Okay, sorry, choose everyone option so that everyone can get to know you. So put in your name, which college you are from, which year are you in, and let the introductions flow. Let me just check actually if, okay, so Harsh, tell us if you're a college student, tell us the college name, the year of study. If you're a professional, just introduce yourself accordingly. Okay. So like Kanav has done, right? BLLB, third semester, Punjab University. So welcome Kanav and Arya. Disha, please, I need like more detailed introductions, not just your name. We can see your name on the chat box. Okay. Just to get a sense of the room. So Swati is a practicing advocate at the Delhi High Court. Welcome, Swati. We've got Anushka, who's a third year student from MET Rajasthan. Welcome, Omisha, who's from Manik Chand Law College in Maharashtra. We've got Disha, which college? Disha Sharma and Shruti. Shruti is from MJPR. Shivansh, welcome everyone. There are a lot of you. Twinkle, Tejal, please put in the full introductions. We've got Drishti from first year at KSLU. We've got Jaskaran, who's a final year. Jaskaran, I think we have met before. Okay, so Jaskaran is from final year, Punjab University. Awesome. Welcome everyone. As you can see, we have people across the country. Jeet is from Calcutta. Calcutta is like my second home. Okay, we've got Gurnoor from ULS, Punjab University. Punjab is also my second home, or it's the first home actually. Okay, Dhruv from VIPS. Awesome. Welcome everyone. We've got Eklavya as well. Eklavya is a good friend and a fellow BNI member. Special welcome to you, Eklavya. Jayant, Malika, Pratibha, Naveen, Remy. Okay, so Samiksha has a message for me. Let me read that out. Okay, not a problem, Samiksha. That's fine. Simran, Toshit, so everyone, welcome. We've got so many of you. Welcome, everyone. I'm really sorry I'll not be able to read out all the names, but Gangadhar and Anne and Rupal, Bhaskar, Devjay, Devjot, Kaur, welcome, everyone. Okay. Awesome. Cool. So it is 7:03 right now. Let me tell you how this webinar will proceed today. Okay. I'm sharing my screen. Samiksha, I hope my screen is visible. Okay. So let me tell you about the structure of the webinar. From 7 to 8:25, actually right from 7:10, I'm going to do a quick introduction, going to do some marketing as well. And then Samiksha is going to take over. Samiksha, as I've told you, is an expert in criminal litigation. She teaches the criminal litigation course. She has worked with the likes of Mr. Satish Maneshande, who I now know. Earlier, of course, I knew that he's the lawyer for Mr. Shah Rukh Khan. Now I know he's Mr. Sanjay Dutt is also his client. Okay. So Samiksha is going to take us, through this 1.5 hours. She's going to tell us the practicalities of check bounce cases. So students who are attending this webinar, our intention is that if you do this webinar and in your internships, you get a case related to check bounce. Your seniors are going to be like, wow, from where have you learned all of this? Okay. And if you're a lawyer, if you're a young lawyer, you want to probably get into, you want to start handling cases around this area, you will be able to, after, of course, a bit of practice, right? From 8:25 to 8:30, I'm going to share the certification details. Let me be very clear, folks. We discourage, let me repeat, we discourage certification for webinars. I personally don't think it adds value, but some of you might need it for your CVs, etc. So for a small logistical fee, you can get the certification. Okay, I'm going to share the coupon which you can use and get these certificates. Okay. Now, the purpose of doing these webinars is twofold. One is we strongly believe that law students deserve practical education in this country. These webinars are a means through which we do that. We deliver practical education through this. The larger mission which Loctopus has is to enable informed and inspired careers. Okay. The second reason also is to give you a taste of what our courses do. So we have online certificate courses which are anywhere between 1 to 3 months long. These webinars are also intended to give you a taste of the course. Okay. So from 7 to 8:30 p.m., you're going to get that. Now, if you're interested to register for a criminal drafting course, especially, then you have a bonus registration opportunity from 8:30 to 9:15 p.m. People who register between this time frame, now we want to give you an incentive if you take the action right there, right then. Okay, you'll have a bonus registration opportunity. You can choose to register for our courses. In case you do not like the webinar, or in case you are not interested to do our course, feel free to exit the webinar at 8:30. The webinar will be complete for you at 8:30 p.m. Okay. A bit about me, and Samiksha, I will request you can quickly introduce yourself as well. A bit about me. I graduated from NUJS Calcutta in 2013. I started Loctopus in 2010. And folks, all of you who are here, thank you for your trust in Loctopus and Loctopus Law School. Okay. In 2015, folks, I wrote this book called Law as a Career, which was published by LexisNexis. And in 2020, we started Loctopus Law School. And over the last 4 years, more than 18,000 people have done our courses with an average rating of 92.5 on 100. Okay. Currently, I'm also training to be an ICF certified coach. And I've been very fortunate to have given TEDx talks twice. That's a bit about me. Samiksha, do you want to quickly introduce yourself, please?
Tanuj, thank you so much. Hi guys, really delighted to be here and welcome to Loctopus Law School. I'm Samiksha. As Tanuj very humbly introduced me, I'm practicing as a litigator. My areas of interest are criminal laws, matrimonial laws, and consumer laws. I practice across the courts of Chhattisgarh. Prior to this, I was practicing in Bombay. Firstly, I was with Mr. Yugmohit Chaudhary, and we dealt especially with death penalty. And then I worked with Mr. Satish Manishinde, wherein we looked at all kinds of cases dealing with criminal laws. Then I moved back to my hometown, Raipur. I worked for some time with Mr. Faisal Rizvi, who's again a very renowned lawyer here. And he also specializes in criminal cases. Then I've started my independent practice. I'm currently also pursuing my PhD in criminal laws. And I'm also a certified POSH trainer, and I'm undergoing my POXO training as well. And I'm also a learning manager at Loctopus Law School, which gives me immense joy and immense, pleasure to teach, to interact, and to be here with you all. And thank you again for coming.
Right. Thank you, Samiksha. So quickly, folks, from 8:30 to 9:15, this is what the bonus registration opportunity is going to look like. You can get a 1,000 rupee discount on the criminal drafting course, of which this webinar is like a part of. Okay. You will get free access to drafting a legal notice course. This is a self-paced course. The criminal drafting course is a live course worth rupees 2,600. You'll also get free access to the self-paced workshop on all about case laws, because again, it's a critical topic, right? Reading case laws, analyzing case laws. So the total bonuses are worth rupees 4,800. And of course, we are going to share the details again at 8:30 p.m. Now I'm done with the introduction and the soft marketing, and I'm going to leave it all to Samiksha, who is going to tell you about check bounce cases. I'm also going to listen to you, Samiksha, as a business
Thank you,
person,
Tanuj.
as a lay person. And okay, folks, one more request. If you have any questions, please put it on the Q&A box. Please do not put your questions on the chat box because it is difficult to track them. Please put your questions on the Q&A box, and we are going to answer your questions midway. Okay, Samiksha, give me a prompt and I'll be
Tanuj.
of service. Okay, folks,
Thank
Samiksha,
you.
it's over to you now.
Thank you. Thank you so much, Tanuj. Okay. So before I start, I just want you all to show me a Zoom show of hands as to how many of us are completely reliant, completely dependent on Paytm, UPI, GPay for making payments. I mean, I'm going to be the first person raising my hands because I actually have to pinch myself and remind myself to actually carry my wallet outside. So can I have a Zoom show of hands, please? Okay, lots of you all. Perfect. So that makes many of us. But this is all about a digital era and an era of online payments, right? Where we are digitally heavily reliant on technologies like UPI or NEFT or net banking or RTGS for making payments. But speaking of commercial transactions, we are still very heavily dependent upon the rather traditional modes of payment. Can anyone tell me what these modes of payment are? Now that you're here, I'm assuming you know a little bit about the topic. So can anybody tell me on the chat box? Checks, yes. Cash, DD, promissory notes. Amazing. That's great. All right. So now that we have laid down the base of what we're going to study today, I'm just going to start sharing my screen. Just give me a prompt, Tanuj, if you can see my screen.
Yes, Samiksha, it's visible.
Perfect. Thank you. All right. So when these transactions increased, okay, when the check transactions became very, very prominent, there was a need to regulate those because they were going out of control or people were heavily misusing them to, get away with the law, to cheat people. And hence came about the law of the Negotiable Instruments Act of 1881. Now, for all those who, like me, have studied commerce in their 11th and 12th standards, remember when we were told about the three kinds of bills of exchange, promissory notes, and checks? These are the negotiable instruments. But what do you mean by the word negotiable instruments? It basically means any promissory note or bill of exchange or check payable either to the order or to the bureau. Now, these negotiable instruments are only paid for a certain amount of consideration. What is the consideration? When you have some amount of money or some amount of liability that you owe to any other person, that is known as a negotiable instrument. Some other traditional kinds of instruments were also hundis, which don't exist anymore. But we primarily deal with promissory notes, bills of exchange, and checks under the modern laws. Today, we'll be concerned and only talking about the checks as the regular modes of payment because they are the ones that are covered under the Negotiable Instruments Act, Section 138. If there is a dishonor of a promissory note or a bill of exchange, it's a separate proceeding altogether, and those proceedings are civil in nature. But today we are going to look at the criminal side of things. So before moving ahead, there are certain presumptions that you should know about the negotiable instruments. Negotiable instruments are covered under Section 118 and 119 of the Negotiable Instruments Act. Now, as I told you, every negotiable instrument is based upon a consideration, is drawn upon a consideration, which means one person owes something to the other. The second presumption that you will always have with regards to the NIAs or negotiable instruments is that it will lead up to the date which is borne on its drawing, right? The third presumption that you must always have is regards the time. Now, these timings are two kinds in nature. One could be the time of acceptance. The other could be the time of transfer. Always remember that the time of acceptance will only be understood when it is accepted within a reasonable time and before its maturity. maturity is a set date given for it. What is the set deadline given for checks? We'll be covering in some time. The other kind of timing we are concerned with is with the time of transfer. So it becomes the duty of the person making such negotiable instrument that he should issue such NI before it matures, so that it gives a reasonable amount of time to the person you are giving it to for it to be issued or for it to be drawn. The other presumption with regards to the negotiable instrument is the order of endorsement. Order of endorsement means what is it basically telling you? What is it basically about? What is the amount you're talking about? Is it 20,000 rupees? Is it 5 lakh rupees? Is it 10,000 rupees? What is it exactly endorsing? All right. Other important considerations are stamp and holder in due course has got its consideration. So stamp means when it is lost, when the negotiable instrument is lost, it will be presumed that it was properly stamped by the person who has issued it. All right. And lastly, the last presumption that we need to know is holder in due course has got it for consideration. So a holder in due course means when person A issues any kind of negotiable instrument to person B, and while this reaches B, it is given to a person C to hold it for some time, then that person will be known as a holder in due course. Such holder in due course will be assumed to have an innocent state of mind with a bona fide intention and to not sway away the law and to evade it. Now, what are the instruments covered under the Negotiable Instruments Act? As I just told, there are 3 kinds of negotiable instruments or credit instruments. One is checks, number 2 is promissory notes, number 3 is bill of exchange. For a visual representation, you can see this is how a check looks like. I'm sure a lot of us or most of us have already seen what a check looks like and what are the details that are entailed on the check. The second image you can see here is a bills of exchange sample, wherein you can see how a bill of exchange looks like. So a bill of exchange tells you that, okay, 3 months after the date, pay to me or to my order the sum of rupees 25 lakhs only for the value received. So it is drawn by one person. The person who draws this is known as a drawer, and the person who it is drawn to is known as a drawee. All right. The third kind of instrument that you can look here is known as a promissory note, which means that, yes, I promise you today that I will pay you X amount of money by this date. All right. And it is stamped and sealed by the person. Now, what are these instruments? These are substitutes for actual money. I can't go to the shop and give them a check for their perusal, right? I can go to the shop, give them the check, but they will have to, at the end of the day, encash it to be able to properly use it. These instruments are also the exceptions to the rules of privity of a contract. Can anybody on the chat box tell me what do they understand by privity of a contract? Any contract enthusiasts here? New person, right? Between the person between whom the contract is made. Only parties can enforce. Legal parties involved in a contract. Only parties in the contract can sue. Yes, the parties and the beneficiary of the contract. Absolutely correct. The law of privity of the contract tells you that there needs to be a prior contract between the parties for any transaction to be made. But the negotiable instruments are an exception to that. There does not need to be any prior contract between the parties to get into a commercial transaction at the moment for the bills of exchange or, promissory notes or checks to happen between them. Now, these instruments are transferable by delivery from one person to the other person. And while this position changes from one person to the other person, the rights also transfer from one person to the other person. So these are written documents which create your rights, and it creates in the favor of the person who such instrument is drawn to. All right. Now, what is a check and who are the parties? As I told you, today we'll not be speaking about the other kinds of negotiable instruments. We'll be just concerned about the check, because when they are talked about, their remedies are civil in nature. Today we are going to be dealing more with the criminal side of remedies and how you can deal with the case of a check bounce. So what is a check? Check is nothing but a bill of exchange which is payable on demand. Now, payable on demand being the key words here. Why so? I cannot ask Tanush today to pay or to give me a check just like that for no reason at all. But if I am an employee of Loctopus Law School, there is a certain salary that I am prescribed to, against which there is liability on Tanuj to pay me. I hope that is understandable. And once Tanuj makes a check payment to me, it would be deemed as if this is payable on demand and this is for a legally recoverable liability. Okay. Now, such issuance of check can be for securing the proof of payment. Now, I understand we've all gone digital. We are moving towards online modes of payment, as we just discussed, such as NEFT, RTGS, or net banking. But sometimes when you're talking about commercial transactions or when there are multiple or huge transactions involved, checks are still very widely and commonly used as modes of payment between one person or one company and the other. Now, these checks could be used for anything, for payment of anything. It could be for repayment of a loan. It could be, as I just said, payment of a salary, payment of a bill, payment of school fees, payment of any kind of fees rather. So let's suppose I go to buy a fridge. There's no one way that I can make the payment. The mode of payment is completely dependent upon my choice, my convenience, and the options at my disposal. I can make this payment through Google Pay. I can make this payment through cash, but I can also make such payments through check. Now, there are certain parties to a check, okay? The person who writes the check, the person who draws the check, or the person who's the author of such check is known as the drawer of the check. Now, you have to understand that whenever you open a bank account, there's a certain amount of money that you deposit in that bank account. And when you open that bank account, you must receive, certain documents from the bank, such as your checkbook, such as your card, or your debit card or your credit card, and any other details that are relevant to your bank account. Now you become the primary account holder or a joint account holder of that bank account, right? So you can validly sign on such checks. And when you sign on such checks, you become the drawer. All right. Now let us also understand everything in a grand scheme with an example. Let's suppose I get into an agreement with Tanuj. Okay, so Tanuj is a wholesaler of Kolhapuri chappals from Kolhapur. And I am opening this very unique boutique shop in Raipur, wherein I bring in antiques from different parts of the country to sell here. Now, Tanuj is really intrigued by this idea of mine, and Tanuj is like, okay, Samiksha, let's do this business together. I get into an agreement with Tanuj, wherein I tell him, okay, Tanuj, I will be making you quarterly payments. So quarterly means every 3 months, I will be making a payment to you, depending on how much I buy from you and what is the, a demand and supply in the market at that point in time. Tanuj very keen, so very happy to do this business and expand his Kolhapuri tradition across the states, decides and agrees and gives a go ahead. Now, for the first 2 years, let's suppose everything goes fine, everything goes hunky-dory. Now, I am supposed to make a payment for the October, November, December quarter of 2023, and this payment is supposed to be made by me, let's suppose, on January 24. I really hope you keep these timelines in mind. So Tanuj tells me, so I sell chappals and Samiksha owns a cool boutique shop, not fair. But Tanuj, I am going to be selling your Kolhapuri chappals in my boutique shop, and that is what makes it cool.
Yes,
all right.
Definitely.
So please keep these timelines in mind, okay? Because this will help you establish the entire narrative of how to move about timelines in a check bounce case, because that is of paramount importance. All right. So up until 2 years, everything is fine. I am supposed to make the payment for October, November, December quarter of 2023 to Tanuj on January 2024. But then I go to Tanuj and I tell him, Tanuj, things are not looking very fine at the moment. There's a lot of loss of business that's happened with me. Can I make the payments to you in the next 2 months? Tanuj, being very understanding, very kind and considerate of my situation, pecuniary and financial situation, he says, no problem, Samiksha, that's fine. Very patiently, so Tanuj waits till March. Okay, on 1st of March, Tanuj sends me a message and email saying, Samiksha, how can we move about the payment? Because we are releasing goods to you, but I also have to pay back to my vendors. I dilly-dally, Tanuj. I move things here and there. And what I do is I issue a post-dated check to Tanuj. Now, two things to keep here in mind. Number one, the drawer. Number two, the post-dated check. So I am the person making this check, which makes me the drawer. Post-dated check means when a future date is written on the check. Now, this brings me to a very important point, guys. Whatever date is written on the check, from that date, you can approach the bank within 60 days, 60 days to encash that check. All right. So let's suppose I issue the check to Tanuj with the date of 1st April being written on it. And this is the check that I issue to him on 10th of March. Okay. And I tell him, Tanuj, listen, I am not going anywhere. I am ready to make the payment. Just be a little patient with me. But to assure you that I'm here, I'm giving you a post-dated check. You can go to the bank anytime post 1st April and get this check encashed. Now, it is very well within Tanuj's rights to approach the bank from 1st of April to 30th of May or 31st of May, roughly, okay, to 60 days from when the check is issued. All right. Now, in this situation, this check is drawn in favor of Tanuj. So he will become the drawee. All right. The third important party in the check will be the payee. So payee will refer to the party on behalf of whom the check is drawn. All right. So payee will be also the amount will be specified in the check as is payable. Sorry. I'm really sorry, guys. Thank you so much for pointing it out. I just lost myself there in the grand scheme of things. Tanuj will become the payee while my bank will be the drawee. When Tanuj will put that check for encashment, it will be deducted from my bank account and that bank will be the drawee. Now, Tanuj does not need to go to my bank. Let's suppose I have a bank account in Kotak Mahindra and Tanuj has a bank account in HDFC. Tanuj doesn't need to go to Kotak Mahindra to get that check encashed. Okay? Tanuj can simply walk into HDFC, give that check for encashment, and that HDFC bank in this regard will be known as the payee's bank. The payee's bank is the bank of the payee where they have a bank account and where the amount of this check will be deposited or credited. So I hope we all have all the parties clear to us. The first person is the drawer. So in this case, I will be the drawer, whereas Tanuj will be the payee because I am drawing this check in his favor. My bank from which the amount will be debited will be known as the drawee, whereas Tanuj's bank where such amount will be credited will be known as payee. Payee's bank. Okay. Now there are lots of situations where things don't go as you plan them. All right. Sometimes when you go and present that check, it is not necessary that it will be encashed as is. Okay. So let's suppose in this situation only Tanuj goes to the bank to get this check encashed on 10th of April. All right. And on 15th of April, Tanuj gets a call from his bank, which is HDFC Bank, that there are no funds in Samiksha's account and hence this check stands dishonored. Now, what do I mean by this? So when any check is drawn for a legally enforceable debt, in this situation, there was a certain payment that I needed to make to Tanuj, right? It was against a legally enforceable debt. Now I cannot recruit Tanuj, or Tanuj cannot recruit me and tell me, listen, Samiksha, you have to kill some other person. I kill some other person and I come back to Tanuj and I ask him for payment. And when Tanuj presents that check to me and that gets bounced, I can't do the court saying, listen, he's not paying me. I did the job he asked me to do. You can't do that. You can only present the check for a legally enforceable debt or a legally enforceable liability. So once you approach the bank, there is a legally enforceable liability. You present this check within 3 months. There is a demand to pay this check. And after this demand, such drawer, that is me in this case, if I fail to pay, I will have said to dishonor. the check. Now, there are two terms that people get confused with. The first term is check bounce. The second term is check dishonored. Do they mean the same thing? Relatively, in a broader sense and scheme of things, yes, but very closely speaking, as a lawyer, no. Check bounce can per se only and only happen when the drawer's account has insufficient funds. All right. But check dishonor can happen in multiple situations. Let's look at those. This is an actual check written slip that I have presented in front of you, which has
Samiksha,
listed down.
Samiksha, sorry to cut you short. Before we begin, can you just look at the chat box? There seems to be some confusion. Maybe you can clear it.
Sure, Tanuj.
Yeah, folks, great that everyone is responding and taking a active part. I'll let the expert clear the doubts for you. Samiksha, are you able to check the chat messages?
Yes.
Yeah.
It's 60 days only, Tanuj.
Okay, awesome.
It has been amended now.
Right.
Yes.
Right.
All right. Okay. So these are the certain circumstances for check bounce. These are all the broad reasons that can be given in case the check dishonors. All right. So the reasons could be insufficient account balance, as I said. The other reason could be expired validity of the check. So if I'm going beyond a prescribed date, or, the pre-date has been written on the check, somebody has given me a pre-dated check, and then I present to the bank at a very later stage, the check can come back dishonored. There is any kind of overwriting on the check. So once anything is written, if you overwrite on it, the bank clearly, dishonors your check. The check is damaged. So if it's torn from any edge or any corner, it will be supposed to deemed as if it's damaged. There's a mismatch in the signature. All right. So the bank will always ask to sign you in the front page and the back side of the check as well. So if there is a mismatch in the signature, in that case also your check can come back dishonored. If there's a mismatch in amount or digits, now I understand all of you have seen a check before. That is my presumption. So you must know that we write 10,000 only in digits also, and then we will write it in, alphabetical letters as well. So if there's a mismatch in any of those numbers, that could be one reason. Now, another big reason could be stop payment. So for example, Tanuj presents this check on 10th of April. This request comes to me. I get a message from our bank saying Tanuj is asking for a payment of 250,000 rupees. And I ask my bank to not pay it to him. I stop such payment. Then that is another reason for check dishonoring. So lots of reasons according to which a check can be dishonored. So I hope you understand the difference. Check bounce is specifically used when there is an insufficient account balance in the account of the drawer. But check dishonor is a general umbrella term that people use when any kind of return has happened from the bank to the check. Okay. Now, some important provisions in the Negotiable Instruments Act that we should know of are present between sections 138 to section 142. Now, section 138 specifically talks about check bounce, whereas some other important relevant sections are section 147. This is a section which makes the offense compoundable in nature. Now, compoundable offense is any kind of offense which can be settled between the parties outside the court or with the permission of the court, and giving the notice to the court saying, listen, we have settled our, issue outside. We do not wish to pursue this case any further. Now, our CRPC and now the newly constructed Bharatiya Nagarik Suraksha Sanhita in their Schedule 1 lists down very categorically about the different kinds of compoundable and non-compoundable offenses. It is also mentioned under section 320 of the CRPC. It will give you a table as to what are the offenses that are compoundable in nature, what are the offenses that are compoundable in nature with the permission of the magistrate, and which are the offenses which are completely non-compoundable in nature. So check bounce, it's a very non-serious category of cases. It is generally dealt as a summary trial or a summons trial, which means it's a very easy time-bound case that should be disposed of very speedily. So to reduce the vagrancy of cases in the courts of law and to reduce red tapeism, and hence they should be dealt with in the utmost diligent manner. So it also makes the act of check bounce compoundable in nature. Other important addition that I want to make here is that for people who have interned at at courts before or have seen lok adalats happen. What is a lok adalat? So every 3 months or so, on the second of Saturday, the district courts will have something called a lok adalat, wherein they list all the cases that can be settled between the parties outside the court. So you will see lots of check bounce cases being listed on the lok adalat day for the parties to come together to sit down and resolve their disputes amicably, to hear both the parties out in a speedy manner, which would not otherwise be possible if this was happening inside the court law where tariq pe tariq scene is happening, right? So here the court aims, okay, you guys come sit down. The accused person will explain his situation, probably, perhaps, hopefully make a promise of the payment, and this case can be done away with and be settled outside the court. Other important section that we need to take into consideration is section 139. Now, section 139 is the presumption. Now, generally speaking, when I talk about criminal law, the entire principle of criminal law is based on beyond a reasonable doubt, and the entire presumption is in the favor of the accused person. Meaning thereby, up until the point the prosecution is able to prove that this offense was committed by the accused and the accused only, and there is no other plausible possibility of anybody else who could have committed this offense, only then will the accused be deemed as if he was a convict in this case post the judgment. So that's the general presumption, and the standard is beyond a reasonable doubt. In this regard, the burden of proof shifts. Hence, the check bounce cases are not completely criminal cases. These also have some elements of civil laws. So this is why they are called quasi-civil, quasi-criminal cases in nature. So 139 will set a presumption in the favor of the drawee that such check was received by him in discharge of any debt or liability of the drawer. So if Tanuj goes and makes a case against me in the court of law, the presumption will be in his favor. He will be given a little more preference, and it will be assumed that, okay, if Tanuj does have a check in his hand signed by me, it will be definitely for the discharge of a legally enforceable debt or liability. Now, such discharge could be for the whole liability or it could be for the part liability, which means, let's say I have to make a payment of 5 lakh rupees to Tanuj, and I'm making a payment, I'm making a check of 2,50,000 rupees, it will still be considered as a very valid enforceable part liability. All right. Then we have section 143, which deals with trial of cases under section 138 as summary proceedings. As I just told you, the nature of check bounce cases will be summary trials or summons trial in nature. Now, these proceedings will not be withstanding anything contained in the CRPC or BNSS. All right. Always remember when there is a special act for anything, the special law will always prevail over the substantial and the procedural laws of the country. So when there is a special law for check bounce cases, which is the Negotiable Instruments Act, all the proceedings will happen under the Negotiable Instruments Act and not under the CRPC per se. Having said that, the application made under the check bounce will follow the format of a private complaint made under a Section 200 application of the CRPC, which is the private complaint case when one person approaches the court to make a case against the other person.
Okay, Samiksha, a couple of questions. I think I'm following the chat box pretty
Sure.
regularly. So one is this issue of 3 and 2 months seems to be there.
Okay.
So you can check. So Bharti Rana says, as per guidelines of the Reserve Bank of India, the validity period for check from the date of issue is 3 months. These guidelines came into effect from April 1. So there is that one to be.
Yeah.
And Sehajpreet says, is the presumption in favor of payee or the drawee? And Shweta says, ma'am, it should be in favor of the payee. Section 139 says that. Could you clear a couple of these things?
Sure, Tanuj. I'll take them one by one. So number one, Sehajpreet, the presumption is in the favor of the drawer because drawee is my bank. So the presumption cannot be in favor of any bank, right? The two parties that we are concerned about here are the drawer and the payee. In this example that we are just discussing, Tanuj is the payee, I am the drawer. So the presumption will be in favor of the person who such check is made to. The person who's holding such check, that is Tanuj. That yes, there is a valid legal enforceable, liability that I have on Tanuj.
Right. Prapanja also said that, okay, just a second. I think there was one more question.
Yes, Tanuj, I also want to address, she has very rightly pointed out that there were RBI guidelines which says 90 days, but then there was an amendment in the 2018 Act which says the limitation period is only 60 days now.
Right. And Debaji say NIA Act cases are always tried in the magistrate's court, not in
Yes.
the civil court. Could you address that?
Absolutely. Thank you, Debajay, for pointing this out. So as I said, it's a criminal case, but it's a quasi-criminal case. What I mean by that is it is not completely criminal in nature. It has some elements of civil laws attached to it. I'll tell you why. If you look at check bounce cases, if you, for example, also look at domestic violence cases, for example, in these kind of summary trials, the intention of the court is to recover the losses and bring back the situation to as they were. The primary intention of the court is never to punish the person. You will see in check bounce cases also, if you go by the bare reading of section 138, it talks about, up to twice the amount of check be given as punishment. Imprisonment is optional in nature, or a non-bailable warrant, which we'll be discussing as we move through the slides. These are optional in nature, and they are only and only exercised by the court when they absolutely see or they're able to assess that this person, who's the accused person in this case, is trying to abscond their liability or is trying to flee away from the court. So to only secure their presence, will they arrest him if the situation seems really likely that they will, evade and go away. But the primary consideration in these kind of cases is never to punish the person, but only to recover the unlawful losses that has happened to one person against the other. So in this case, the example that we are discussing, the primary objective of the court will always be to recover the losses that Tanuj had to incur because of me. It will not be to punish me, because if they just throw me in jail for XYZ reason, not giving me a chance to pay back, then the entire purpose of this section will defy. Hence,
Right.
It's a quasi-civil, quasi-criminal case. So that's one way of putting it. The second reasoning behind this is also Debajay. Check bounce cases will be civil in nature up until the point Tanuj decides to go to the court. Because when he issues a notice to me, he will only be asking for something called recovery, quote unquote. And recovery is a civil ingredient. He's asking me to pay the money back to him. Once Tanuj sees that Samiksha is in no mood to pay me back and Tanuj goes to make a complaint to the court, then the nature will change and it will become a criminal complaint. I hope I was able to sort that doubt out for you.
Right. And folks, just a couple of things. One is, please put the questions on the Q&A box, the chat box. Discussions are fine, by the way. So some of you, discussions are fine on the chat box, but put the questions on the chat box, please. And Samiksha, let's be mindful of the time as well.
Absolutely.
And, so yeah, we have 45 more minutes. So folks, keep the questions coming. Yes. And Samiksha, let's move ahead.
Sure. Thank you so much, Tanuj. All right. The last section I talk about here is section 140, which means the drawer cannot take this defense that the check may be dishonored on presentation. Now, if I have given Tanuj a check on which the date says April 1, 2024, and Tanuj goes to the bank on April 10th, 2024, later I can't go to the court and say, when Tanuj files the case against me, I can't go to the court and say, Arey, I didn't know money was not there. Tanuj didn't tell me before he was going to the court. Because if I'm writing the check for a certain date, it is well within Tanuj's right to go and approach the bank and ask for that money to be encashed, right? So I cannot take that defense and I cannot abscond my liability. All right. Moving forward, how is a check dishonored? Now let's move step by step. So I hope a lot of your answers will be covered by this slide. The first thing that will happen is check will be drawn by the accused on account maintained by him with a bank. So as I said, I have a bank account in the Kotak Mahindra Bank. I will draw a check of, let's say, 2,50,000 rupees in account of Tanuj or against Tanuj, that a liability I owe to him. Now, the second step will be this check will be drawn to discharge a debt or a liability. The third step will be this check is to be presented to the bank within 2 months. Okay, I stand corrected. Please, it is 2 months, which is 60 days from the date that is drawn to the bank. Sahajpreet, the procedure that is followed here will be CRPC. Under section 200, the private complaints that you make, the similar procedures will be followed here. The fourth step in this regard will be that this check will come back returned or unpaid by the bank due to the reason given by the bank. Now, do you understand at all the reasons that we listed down that, the bank could send back a return memo with? It could be the account was stopped, this account was closed, this account has insufficient funds, the information entered on the check is incorrect in nature. So multiple reasons. When your check comes back dishonored or when your check comes back bounced, then this person, Tanuj, will have the liability to write to me a notice within 30 days. All right. Now, Tanuj will make a notice to me within 30 days of such check bouncing. So let's suppose Tanuj went to the bank on 10th of April. This check comes back returned on 15th of April. So from 15th of April to 15th of May, within the period of these 30 days, Tanuj can issue to me a valid legal notice asking me to pay back the money within 50 days. Now, these are the timelines I really need you to take care of, 30, 15 and 30. So within 30 days, Tanuj has to send me a legal notice. So from 15th April to 15th May, Tanuj has to send me a legal notice. In that legal notice, Tanuj has to mention and write that, Samiksha, I give you the time of 15 days from the day you receive such notice to pay this money back to me. All right. So let's say Tanuj makes a notice to me on 20th of April. All right. This notice reaches me on 25th of April. So from 25th of April, when I am in the receipt of such notice, I have the time till 10th of May to pay Tanuj the money back. Post this 15-day period, Tanuj has the right to go and approach the bank within 30 days and file a case against me for such check bounce. I'm going to repeat this once again for your understanding and for your perusal. Let's suppose Tanuj goes to the bank on 10th of April. 15th of April.
Samiksha, currently the slide is remedies. Do you want to shift to the previous slide?
Yes, Tanuj, I'm here
Okay.
only.
Okay, awesome.
Yes. All right. So, Tanuj goes to the bank on 10th of April. This check comes back returned on 15th of April from the bank, and the reason stated by the bank therein is this payment was stopped by the drawer, or let's suppose there were insufficient funds in the account of the drawer. Tanuj will issue a legal notice to me within 30 days. Okay? So Tanuj writes a notice to me on 20th of April from his legal representative. And in notice, it is written that, listen, Samiksha, from the date you receive such notice, you have to pay my money back within 15 days. Otherwise, I'm well within my rights to approach the courts of law and hold you liable under section 138. Now, there are two ways I can go about it. Number one is I pay Tanuj the money back and I settle this outside the court, right? And the second thing would be for me to not pay Tanuj the money back, to not even reply to his notice, or even if I reply to this notice, my reply is very vague or very spreaded in nature, which sort of gives the idea to Tanuj that Samiksha is not in a mood to pay. So from the date this notice is received by me, if I fail to make the payment within 15 days, which is 10th of May in this example, Tanuj is well within his rights to approach the court from 10th of May to 10th of June. within 30 days, Tanuj has to approach the court and hold me liable under Section 138 of the Negotiable Instruments Act of 1881. I hope I'm going in the correct direction up until here. If there are any questions, I would take them up now.
Let's address some questions in a rapid fire sort of a manner. I'll first let everyone take a breather from the check bounce cases because there's a lot of information. It's very technical, and so make sure you're doing a great job. Okay, so let's take some quick questions, but I'll first take a non-check bounce questions, to give
Sure.
everyone some rest. So Simran is asking, is Chhattisgarh a safe state? I'm a judiciary
Absolutely.
aspirant and my parents are a bit, worried. Would it be okay to be there and live there?
Absolutely. It's a beautiful state. I think Tanuj has lived here for quite some time also, and Tanuj has spent the time in a district which is the most infamous when it comes to, talking about Chhattisgarh. When we talk about Chhattisgarh, I think the first presumption that comes to mind is, oh, Naxalites hai, oh, it's not safe. But it's actually one of the safest cities places to be for a girl. I think I can walk out on the road at 12 in the night and have no fear. And I think that's it's a very basic borderline liberty to have, but nonetheless, a very relief, a
Right.
very
And
high
I
sense
would
of
I would
relief.
agree with that. I think people are really nice. It's actually I love Central India. See, I'm a North Indian, and with all due respect to all North Indians here, many of my friends, but I think Central India is also wonderful, and Simran, it is absolutely safe. Okay, now let's take some questions. Okay, Narendra is asking if a check is failed due to overwriting, will it fall under check bounce matter?
It will be a check dishonor. As I said, see, um, generally speaking, these terms are interchangeable in nature because 138 covers both check bounce and check dishonoring as well. But it will be specifically a case of check dishonor if there's an overwriting in the check. So in this regard, what you can do is, if there is a cordial relationship that you share with the person who has drawn the check, you can cordially ask them to issue you a new check rather than going the rogue way and filing a case against them.
Right. Earth is asking, what is the remedy for payee in case of expiry and he does not take the check within stipulated time?
Okay, again, that's a very common, mistake and oversight that happens, which a lot of our clients deal with. They will come to us and tell ki, okay, hum le jana bhul gaye. Again, that is the first piece of advice that we give them because most of the commercial transactions that we talk about here are long-standing in nature. You can just very formally, very sweetly request the other person who has drawn such, check to you to present you with a new check. And that should be no problem at all if they are in a mood to validly pay you.
Right. Mehek and Shashank have nearly the same question. What is the validity on undated check? And Shashank is asking, what if the check is no date?
Okay, so there's a recent judgment that I'll also be happy to send you. In fact, Chandigarh High Court also reiterated on this judgment as the Supreme Court did some time back. It said non-dated checks can still be, put into the category of check bounce cases. The person who has drawn such check cannot just get away with the liability of paying the person, and the date on the check will be considered on the date that it was presented to the person.
Right. Earth is asking, can a drawer be arrested immediately on complaint of dishonor of check?
Absolutely not. But there are two, situations to this. See, what happens, Arth, is I told you these cases are summary trials in nature, which means these are very less serious category of offenses, and which is why they're compoundable also. So if you're making a notice to the person only under Section 138, you will not be arrested. But if in your notice you give and mention the sections of 406 and 420, which is criminal conspiracy and criminal breach of trust, in that situation, it will become a case of an FIR, and in this case, this person can be arrested if the sum of money in this case is involved is huge in nature.
Right. I'm taking Jeet's question on the chat box. Jeet, my request is please put it on the Q&A box, but I think it's interesting. Can parties go for arbitration in such cases?
Well, Jeet, that's a very interesting question, but that would only entail when parties have a privy contract to each other, and arbitration is one of their clauses of dispute resolution. So that would only be applicable then. So if that's a clause, then definitely they can do so. The other ways that they can go for are mediation and negotiation as well in such kind of situations. Mediation is a very common strategy that, parties these days apply to check bounce cases when they have a long-standing MOU or a contract with each other. And if you look at it that way, lok adalats are nothing but, a court holding a mediation for you only.
Okay, Ria is asking maybe a question which we have already addressed, but let's do it again because there are many similar. If check is not presented to the bank within 2 months, then what happens?
See, the check will be deemed to have expired. So in that situation, all you can do is ask the other person to reissue you the check again.
Right. Shweta and some other people are asking, can you please repeat the timeline? Samiksha, could we go through that slide once, maybe quickly?
Just give me money.
And Samiksha, you can also address the fact that whether, it's a check bounce as a civil or a criminal case. Just a quick recap of that. That was beautifully explained by you and a couple of people said so. And folks, I've also sent the presentation on the chat box because some of you are wanting to refer to various things, various slides. So you can download the presentation. For you, it will make for a better learning experience. Okay, Samiksha, so the timeline and the fact whether it's a civil or criminal case, and then let's move ahead. Folks, I'm sorry, will not be able to take all the questions, but we'll try our best to take as many questions as we can.
Absolutely. Tanuj, with that, I would also like to answer Meg's question actually, which is something I was going to cover in the next slide itself. Can a check which is bounced be presented to the bank again? 100% Meg, there is no cap on the number of times you can present a check to the bank for it to be encashed, but the bank by itself or by default may stop accepting your check after 1-2 times of its bouncing or dishonoring. All right. Now to answer your question, guys, if check bounces are civil cases or criminal cases. So if I were to make a Venn diagram, I hope you all know what a Venn diagram is. Check bounces will fall 75% into the ambit of criminal cases and 25% into the ambit of civil cases. Now I'm going to explain that in twofold as I just did earlier as well. These cases are quasi-civil, quasi-criminal in nature because the main intention in criminal cases is to punish the person for them to repent the offense that they have committed, or to punish them so that they do not commit this offense against the society again, or they do not become a threat to the society. As opposed to check bounce cases, this is a case wherein the rights are res in personam, which means the rights lie from one person against the other person and not society as a general rule. All right. So when such rights in personam are breached, it is deemed as if one person has, evaded their liability against this other person. And here the intention of the court is only and only to recover the losses and pay back the person who has suffered such losses. So let's suppose the example that I took. In my regard, Tanuj had to face losses of 250,000 rupees because of me, right? In this scenario, the intention of the court at first hand will not be to arrest me or to not be punished or not to be to punish me. It will be asking me to pay Tanuj the money back, which I'm liable to pay back to him in a legal manner. There's a legal debt that I owe to Tanuj that I have to comply and fulfill with. When can an arrest be made in this case? When, let's suppose, Tanuj has filed the case, Tariq pe Tariq ho rahi hai, and I'm not appearing in front of the court again, and then again. In this regard, if the court is able to see, gaze, and assess that this person is trying to evade the eyes of law, what they can do is they can issue a non-bailable warrant against me and arrest me only to secure my presence in the court, to have me come to the court and then ask me to pay. So that's one way of going about it. If Tanuj writes a notice to me, and if in that notice Tanuj mentions that if I don't pay Tanuj the money back, then Tanuj can not only file a 138 case against me, but he can also file a 406 and a 420 case, which is a criminal conspiracy and a criminal breach of trust case against me. Then on the basis of these sections, Tanuj can further even go to the police station and register an FIR against me. And if the circumstances allow, if the case is fit so, then I may be arrested in that regard as well. But otherwise, two things cannot happen in a check bounce case. FIR cannot be instituted on a 138 case and arrest cannot be made on a 138 case. I hope I was able to make you guys understand. If this was satisfactory, you could just send a thumbs up on the chat box so that I'll know I've, cleared your doubts. And with regards to the timeline, just remember the very simple timeline, 15, 30, and 15. 30, 15, 30. 30 days from which the check comes back dishonored, I can issue a notice to the person who has failed to make the payment. So in this example, from the date the check came back dishonored from the bank, Tanuj can issue a notice to me, a legal notice to me within 30 days. Okay? In that notice, Tanuj will have to mention that Samiksha needs to reply to this notice or pay the money back to me within 15 days. 15 days. All right? If I make the payment, well and good, the case ends there. It doesn't go to the court. But if I don't make the payment, or if my reply to the notice is also very dilly-dally, showing my intention to not pay back, then Tanuj is well within his rights to approach the court in the next 30 days and ask the court to have me make the payment for the case. Sahaj, reconfirming you once again, arrest cannot be made in 138 cases solely. You will have to file an FIR under 406 and 420 for arrest to be made in check bounce cases. Otherwise, you can't make an FIR, and where there is no FIR, there cannot be any arrest. I hope you all were very clear with this concept, and I hope we can move ahead now. Now, what are the remedies against check bounce and how to handle them or avoid them? Now, abhi tak we were talking about the rights of the person whose check is bounced, but what happens when you are on the other end? Number one is the resubmission of the check. So what you can do is politely, as the accused person in this regard, just ask the person who you have drawn such check to that, there could be some fault, or, there were no funds at the time you presented this check to the bank. What you can do is you can go back and resubmit this check right now, and I assure you the payment will come through. So that is one way of going about it. The other will be this person from whom such check has been bounced. They can be issued a notice. So in this regard, Tanuj can issue a notice against me and ask me to make the payment. What can I do to avoid such situations? I can maintain sufficient balance. I will verify all the details very, very promptly, very carefully, very skillfully, that all the details mentioned by me are correct and true to the best of the knowledge. And then I will present the check to him with no mistakes at all. I should also keep a track of all the checks. If there are a lot of commercial transactions I'm getting into, or if I'm making a lot of periodical payments to people, I should make sure that there are sufficient funds in my accounts to move forward with the same. A great idea would always be to use online modes of payment such as NEFT, RTGS, or UPI. So they can help you avoid the check bounce cases altogether. But that brings me to a question for all of you. Can the online transactions of NEFT, RTGS, or UPI be also held liable in the court? If yes, under what act? I want you all to answer this question. Yes, there's like a lot of yes. Payments and Settlement Systems Act of 2007. Absolutely correct. So the Supreme Court has held that under the Payments and Settlement Systems Act of 2007, this act was actually introduced when the technology came about and the advent of, online transactions took a toll over the traditional conventional modes of payment. And it said that yes, these online modes of payment will also be regulated as online modes of payment, and they will be dealt with the same principles as check bounce cases are dealt with under Section 138 of the Negotiable Instruments Act. All right. Now, as I told you all that Tanuj will be very well within his rights to issue a notice to me, what are the contents of such notice? All right. And what is a check bounce notice? There are certain pointers I'm going to give you, certain very practical aspects that I'm going to be dealing with. So I really hope you're taking a note or you're keeping in mind of the points that I'm going to talk about. So a check bounce notice is nothing but an intimation. It's like an intimation that you are giving to the other person that I am, taking a step further in pursuance against you to recover my money. And I'm informing you that, listen, I'm giving you last chance to pay your money back. All right. Now, there are certain contents that you need to be very mindful about. Now, of course, this check bounce notice is always advisable that it needs to be made by an advocate with all his details given therein. You can make it yourself as well, but it's always good to approach a legal, representative for the same, because they'll be able to help and assist you in the best manner possible. And they will tell you what the contents are, and hence there is no set format, but there are certain details that you need to make sure that you adhere to. Number one is the name and address of the drawer of the check, which means my name and details, okay, the person who's drawing such check. All right. The second details will be the name and address of the payee. In this regard, I have to enter all the details I have of Tanuj, his name, his address. If Tanuj has a proprietorship firm or a partnership firm or a company and I have to make a payment to that company, I have to mention the details about that company also in that check bounce notice. Thirdly, information of the check presented to the bank for the payment. All right. But before you do that, always give a factual narrative leading up to that payment. So in this regard, Tanuj, it would be a great idea for him to explain in the notice itself, what were the situations or what were the conditions that led up to the payment of that check? What created that legally enforceable liability, so to say? Okay, so Tanuj will mention all the facts. Tanuj will tell, okay, Samiksha had owed this payment to me for which she issued me a check, right? Of dated 1st of April 2024. Now you have to write all the details of the check, what bank was mentioned on the check, what branch of the bank was mentioned on the check, what was the number of the check, what was the date written on the check, what was the amount written on the check. So all the details, you will put them together very carefully so in your notice. Nextly, you will write all the details of the return of the check. So you will give on what date was it returned, what did the bank say while returning it. Now, bank is not your friend. It will not just informally call you and tell you, listen, your check that you presented has bounced. Along with the check you presented, they will give you something called a return memo from the bank, which will tick the reason. Return memo's picture I showed you also. It will tick the reason as is applicable in your case. There will be a seal, sign and date from the bank, and they will return it to you along with the check. So in this notice, you will have to write the details of why the check was returned, on what date was it returned, and what did the bank say. All right. Then in your notice, you will make a reference to how you are liable to legally recover this amount under Section 138 of the Negotiable Instruments Act. Right? How is there a liability that was created? How was this a valid enforceable debt that was supposed to be paid off? In addition to this, I already said this before, but if there are any penal actions as they can be applicable, such as Section 406 or 420 of the IPC, you may mention them as well. And now the BNS. So you can find the parallel section and you can attach them in the notice person. And lastly, you will ask this person who is supposed to make such payment, the drawer of the check, to make the payment or to reply to you within 15 days of the receipt of such notice. All right. Usually we ask for payment back with 18% interest per annum. That is a standard amount that we ask for. All right. Now there is one more very, very, very important pointer that I want to put forth at this point. Whenever you are going to be sending any notice, and when I say any notice, it could be a check bounce notice, it could be a notice under defamation, it could be a notice under Section 9 of Restitution of Conjugal Rights under the Hindu Marriage Act, or notice for divorce. Any notice. Always make sure you are sending it via registered post or via AD. Why? Because when you send a notice via a registered post, you can generate something called a receipt, which will tell you the status of such notice that you have sent. Maybe when Tanuj sent the notice to me, the address was insufficient, the address was incorrect, I refused to accept the notice, I accepted the notice. Whatever the reason being, at the end of the day will be mentioned in the AD report. So always send your notice. In speaking in reference of check bounce, it is compulsory for you to send the notice via AD, because you will have to present the report to the court and tell them why you're here wasting court's time when you could have possibly settled this matter outside. All right, so always have the registered AD report, and these are going to be the contents of your check bounce notice. Now let's look at the other important pointers. All right,
And
number one.
Samiksha, I just wanted to tell everyone. So I'm going to now enable chat. I disabled it. I wanted people to focus on that bit. And Samiksha, you can continue.
Sure, thank you so much, Tanuj. Number one would be always keep the original copies of the check and written memo at a safer place. Now, listen, you have to understand, check is just a piece of paper at the end of the day. It's very easy for the check to get damaged or lost, or anything could happen. So make sure you're keeping the original copy of the check and the return memo that you received from the bank very, very safely with you. As I told you, send the legal notice through registered post, that's RPAD. Also, nowadays, we also prefer sending it via electronic modes of communication, that's email or WhatsApp. Now, the Supreme Court has very categorically said in plethora of judgments at this point that if there's a double tick on WhatsApp, it will be deemed as if such notice was delivered to the person. And then they can't come later and tell her a physical notice was never received by me, because it will be deemed as if they received such notice. All right. Next point that you need to keep in mind is the complainant in matter of section 138A must be the person in favor of whom such check was drawn. Now, if you look at criminal cases in general, it's not necessary that the victim in the case is the complainant as well. If you talk about DV also, it's not necessary if I am going through domestic violence, I have to go and file a case by myself. It can be done by anybody who knows of that offense being happened against me. But that's not the case in check bounce cases. If Tanuj has got a check bounced by me, only and only Tanuj can be a complainant in this regard. All right. Now, check bounce notice is addressed to the person who drew the check, which has been dishonored. So Tanuj can only draw this check against me and no one else. Not my husband, not my father, not my sister, no one else but me only. All right. In case of a company, the NIA Act check bounce is addressed to the company, and the persons responsible for administration and business affairs may also be addressed. Now you have to see it this way. We all know companies are corporeal persons, which means they have their own seal and signatures, right? So when there is a check bounce that's happening on behalf of a company. Now let's suppose, God forbid, that's never going to happen, but let's suppose Tanuj gives a check for payment of my salary from Loctopus Law School and that bounces. In that regard, Loctopus Law School or Loctopus as a company has its own seal and signature, right? So I can move against the company. Now, when I'm sending that notice, I will be making two parties in that case. Number one will be Loctopus through its proprietor, Tanuj Kalia. And the second party in this regard will be Tanuj Kalia through its proprietorship, Loctopus. All right. So any person who's backhand, handling all the business, handling all the affairs can also be made a party, should also be made a party in these kind of cases. Now, your legal notice should include the exact amount for which such check was drawn. All right. Now, we also ask very generally so that whenever a person, like for example, Tanuj makes a notice to me, he can ask me, okay, Samiksha, you owe 2,50,000 rupees to me, so you pay this back to me. But he can also additionally ask me that, listen, it is because of you that I had to go to the lawyer. Nah, otherwise I had no business going to him. So it's because of you I had to go, so you have to incur the fees of my lawyer. Now, very practically speaking, folks, we never get that money when we ask to pay the other person for the legal fees, but we do mention that. So you can't cumulatively write ki, okay, 2,50,000 rupees for payment of the debt plus 50,000 legal fees. So cumulatively 3 lakh rupees you pay to me. You have to very categorically list down exactly what all you're asking for me and your notice should specifically mention about the amount of 2,50,000 rupees. All right. And these transactions should comply with the existing laws. Okay. Now, you all know the timelines verbally, but they should still be mentioned when you're making such notice. And you should be very careful of applying the limitation period while going to the bank for encashment, while sending the notice, while waiting for the reply, and while filing of the cases. Okay, I hope these were clear. Now we'll move. What if you're on the other side? What if you receive a notice for check bounce, or you have a client who comes in and tells you that, listen, sir, I have received a notice for check bounce. How do you respond to the same? Okay. Now, the first advice that I would always give you is try to settle the matter amicably outside the court. So if there is anything that you can do, maybe get into a talking situation and stage with them and tell them, listen, while hey, I might not be able to make the full payment right now, let's just not take this to the court. I promise you to make payment in installments. Just give me, I'm just give me one more chance. I'm promising you. Maybe try settling it that way. Maybe try making the complete payment to avoid the other person going to the court. But if nothing helps, if all else fails, and you do have to, go to the court, you have to send a legal notice, these are the certain points that you should consider. Number one is you have to address the reply. You have to address the reply of the legal notice to the lawyer of the drawer of such notice or the drawee. Now, sometimes banks may also send you a legal notice along with, but that's hardly the case. But if a person is sending you the legal notice, you have to address them point by point, taking every point specifically and answering all the queries paragraph wise. You have to mention all the details, your descriptions, your name and address. In case the person who is making such notice has already given all the details in depth, you can just write, the details are true, correct, and factual to the nature, and they're not being repeated for the sake of brevity. As simple as that. Then you come and talk about the facts of the issue. Now, this is the time to rise and shine and show your side of the story by rebutting, by refuting all the allegations and accusations made against you. If you feel like this person is making an accusation, that might put you in a very bad position. Try explaining what is that person doing and how is their intent malified in nature, or their intent is not good or bona fide in nature, and they're just doing this to sort of meddle you in, legalities and complexities of law. If you've had any prior bad experience with the person who has, filed this notice against you or has sent you such notice, you mentioned about those events as well, that listen, this time that had happened, I had let that go, but now you're coming to me with a malified, vexatious intent to sort of implicate me on a false check bounce case, and I'm not liable to pay you any money. There is no legally recoverable debt that lies from my account to yours, right? It is always ideal that your notice should also go via your lawyer with their letterhead on the paper. All right. Because you have to remember and you have to realize that non-replying or non-adhering to the notice of the sender will put you in a legal implication, and it might lead up to you going to the courts at a later stage. So it's always better to salvage that matter in hand beforehand. I hope I'm clear. I will just take one or two questions before I move any further with regards notice specifically. Any doubts with regards notice?
Right, so Miksha, let me just check the chat box as well. There's a question by Gurish. What are the legal consequences of check bounces of private limited or public company?
Doesn't matter. Same liability will arise, whether it's a private limited, public limited, sole proprietorship, partnership firm. They all have their own seal and signature, so you can very well move against them. And the person who is handling their affairs also.
Debaja is asking, how is the jurisdiction decided where to file the case?
I'll be coming to that, Debaja. Do not confuse anybody. I think in a couple of slides, we'll talk about jurisdiction under section 142 also.
Okay, there will be some course on drafting. We'll discuss about the course later, or we'll start that at 8:30. Samiksha, let me just check. Okay, Arun is asking again about the jurisdiction. Let's say the check is issued in Zirakpur. Zirakpur is a place near Chandigarh, Samiksha, for a person living in Noida. So two different states. The check bounced. What about the jurisdiction in such
I'm
cases?
just coming to that, Tanuj, in the
Okay.
next slide. So I will
Sure.
address
Awesome.
that. Yes.
Okay. Okay. Let me just check if there are one or two more questions that we can take.
I think, Tanuj, I can take Arth's question at this point. With respect to the reply to the notice, do we need to present evidence to rebuttal? Not at this stage, Ansh. You can, of course, tell them about the evidence in writing, but you don't have to physically attach the papers during the notice stage. Always save your evidence for the court stage. We don't send out annexures and exhibits when we are sending the notices. We never do that.
Right. Okay, Samiksha, let's move ahead.
Yes. Also, I would like to address one thing at this point. You can, as Debaja also mentioned, I was going to talk about it. You can file for a counter case also in case you feel like this person is, going in a rather rogue direction and filing a false, making a false complaint of 138 against you. If you feel you have a strong enough case, you can also move and file a counter case against them under section 406 or 420, whatever is applicable. Okay, so that could be cheating or criminal breach of trust if this person is trying to bring to you to recover the losses which you never, had in the first place. Now coming to the question that a lot of you all had, jurisdiction. Now jurisdiction of check bounce cases is covered under section 142. Okay, the jurisdiction will always be in the court of judicial magistrates of first class or metropolitan magistrates in case of metro cities such as Bombay, Delhi, Chennai, etc. But the judicial magistrate of first class can deal with cases which have up to 3 years of punishment, which is also the case in check bounce cases, and they have the jurisdiction over these cases. Now, with the amendment of 2018, there are two places of jurisdiction you can file a case of check bounce under. Come, let's understand those. Number one is if the check is delivered for collection through an account, then the branch of the account where the payee or the holder in due course, as the case may be, maintains the account is situated. Okay? Which means where Tanuj is situated, he can file a case there in the example that we've been discussing. Okay. So Tanuj is in Chandigarh, he can file a case against me in Chandigarh. In my example, Tanuj is in Kolhapur. So Tanuj can file a case against me in Kolhapur. The other place where this case can be filed is if the check is presented for payment by the payee or the holder in due course, otherwise through an account, the branch of the drawee bank where the drawer maintains the account is situated. Now, these might look as very complicated sentences to you, but very simply put, Tanuj can present this case where he stays or where his account is, which is Kolhapur in this regard, or where I stay or my bank account is, which is Raipur in this example. So both of the places will have jurisdiction in these kind of cases. I hope this is understandable. It's very easy. Earlier, there would be 5 different kinds of jurisdiction, which led to multiplicity of proceedings. It led to overlapping of cases and overlapping of jurisdictions. It led to a lot of confusion between the parties because same cases were being filed left, right, and center at different places. But now, only 2 jurisdictions are there, and those are very apt enough, either where Tanuj is staying or whether I am staying. So, whether the payee or his account is, or whether the drawer or his account is, can the cases be filed in the court of judicial magistrate of first class. So, you have to directly go to the court. You can directly file a private complaint. Debaja, why file both to harass the complainant? Because you can't do that. Because in your complaint, you actually have to write that I have not filed a similar case against the similar party in this specific regard. For let's say check number 00001 in any other place. You have to attest, verify, and put an affidavit to it. So you can't file a case everywhere to just harass the person. You should not. That's not ideal because one of these cases will be dismissed by the court and costs may be implicated against you for wasting the court's time. Right? Now, there are certain documents that you need to file while filing a check bounce case. Number one, you need to talk about a legally enforceable liability. So in this case Tanuj has to prove that I definitely incurred a legally enforceable liability against him which I have breached, which is why Tanuj is forced to come to the court today. Second important document that Tanuj will need to put is the original check on record. So the original check that was bounced needs to be put by Tanuj. The third important document is the return memo. So the return memo that is received from the bank needs to be also attached to the application that this person is making. In this case, Tanuj also mandatorily needs to attach the copy of the notice that he has sent to me to prove to the court that, listen, hey, I didn't want to come to you in the first instance. I have gone through the way of how the procedure is to be followed under section 138, sent the notice and a copy of the same is attached. Along with the copy of the notice, as I said, you have to attach the RPAD report. So the registered post report of the acknowledgement, you have to attach to it. Now, the last ingredient of the document that is required is completely optional in nature. So there could be a situation where I am indeed replying to Tanuj's notice. Then Tanuj can, and if my notice shows my dilly-dally nature, then Tanuj has to attach the copy of that notice. If I have not replied, then nothing saying Tanuj can immediately move to the court without attaching my notice also. Now, all of these 5 documents I spoke about are mandatory in nature to be attached to your check bounce application.
So, Samiksha, I think,
Yeah.
We'll have to wrap up in 2 to 3 minutes.
Definitely, Tanuj.
So maybe, we can take questions of whatever has been covered till now. And,
Absolutely, Tanuj.
Yeah. So, cool, folks. Since we have some time limits as well, you can go through the presentation for more details. It's been, of course, a delight listening to Samiksha till now. Samiksha, let's take some questions and
Sure,
then
Tanuj.
complete this segment of the webinar.
Can I stop sharing my screen, Tanuj? I'll be able to see the questions.
Yes. And feel free to take questions which you see are more relevant. I'll also try to do that. Okay.
So
folks,
some questions.
Yes.
I'm sorry, Tanuj, to interrupt you. Some questions are literally a yes or a no answer, so I'll just quickly address those to get them out of the way. Toshit asks, if the signature is different, will it come under the ambit of 138? 100% yes, Toshit. If the signatures are different, you can cover them. If the pay does not complain within 30 days, what remedies does he have? Now, Arth, very valid question. Sometimes it happens that, we fail to send the notice within 30 days. So in this regard, if the parties are in talking terms or if they are okay, we ask the person to issue a check once again and we get it bounced again. Now, this might look like double jeopardy to you as to why somebody will give you a check to bounce, but that does happen. They will give you a check. You can get that bounced again and send a fresh legal notice. Okay. Can we notify the drawer about the check bounce through any other medium, or it has to be legal notice only? Legal notice only. Now, this is a very important ingredient, Hamza, which is given under section 138 itself, that you do have to send mandatorily a legal notice to the drawer of the bank. Can the power of attorney holder file a complaint under 138? No. Because power of attorney is for a certain set of powers and check bounce is not normally covered under that. I put a check for dishonor, but I put the amount 2,50,000 instead of 2,50,000 in Hindi by mistake. Will the check be bounced? I'm not able to understand your question, Rajiv. If you could please repeat for me, I'll be able to help you better. Employers take undated checks from new employees. Is it valid? So, Ashok, to answer your question, I think Tanuj will also be in a position to answer that question. The new employers will always take cancelled checks. And that is only done to verify the details of the bank account and the genuinity of the new employee that they are onboarding. It has nothing to do with a blank check or the employer taking this check to the bank to get it encashed. For how long a check bounce case can continue in sessions court? There is, firstly, Bharti, the case is not in sessions court. Only the appeals will go to sessions court. The cases of check bounce are in magistrate courts, which are the lower courts than the session courts. The cases are usually supposed to ideally wrap up by 6 months or so, but they may take any duration between 1 to 2 years easily.
Right. And Samiksha, there are many questions of the chat box as well, I think, which are very interesting.
Absolutely, Tanuj.
Pushkar Mani is asking at what stage bank is called for examination.
I was reading the exact same question. Thank you for pointing
Mhm.
out, Tanuj. Pushkar, if the bank or the bank teller is to be called for examination, they will be called during the evidence stage. So, very quickly wrapping the stages up for you, what will happen is when Tanuj will file the case, the courts in such kind of cases will issue me something called a summon, asking me to appear in front of the court. I will have two options. I can either say, yes, I'm guilty of not making this payment, or I can say, I'm guilty of not making the payment to Tanuj. If I plead guilty, then of course the court can decide accordingly and there will be no trial that will be held. But if I say I'm not guilty, for whatever reason, Tanuj is filing a false case against me or there is no legally recoverable debt, etc., then the trial process will start. And the first stage of trial in this regard will be the evidence stage, where both the sides of evidence will happen. That is the complainant side of evidence, which is Tanuj in this case, and then my side of evidence, which is the defense in this case. Depending on the evidence, there will be final arguments where we will wrap up the entire submission we have made. We will present our best arguments and evidences that support our case. And on the basis of these final arguments, the magistrate court or the JMFC will pronounce the judgment. On the basis of this judgment, of course, because it's a case, one party will be unhappy, they can appeal to the higher court. The higher court in this regard will be the sessions court. I hope this gave a little clarity as to what the stages of the trial in check bounce cases are.
Right. So Samiksha, last couple of questions now. So Atul is asking, in a joint account, will both the persons be liable?
No, the primary account holder, you can just make him liable. But if you do want a notice to reach the other person also, you can send a notice to both the parties. We usually do that so that we make sure that the notice has reached the person.
Right. And Vaishnavi Lokapur is asking, if I receive notice from WhatsApp and later through RPAD, the limitation applies from which date?
From the date it's first received by you. So WhatsApp in this regard.
Okay, awesome, folks. This is a fascinating topic. I just realized how technical it is as well, and Samiksha, great job in explaining the technicalities. As I discussed at the start of the webinar, we are in terms of the knowledge delivery part of this session, we are complete. I'm sharing the webinar certificate link and the code with you. Again, I'm saying we discourage people from attending webinars just for the sake of certificates. We believe you should attend these webinars for your knowledge, your understanding, practical upskilling. But we do understand that sometimes people need certificates to show, etc. In official records. So I'm sharing a link with you. There is a logistics fee of ₹100. So you can click on this link. You can put this code, and the e-certificates will be sent to you within 7 working days. Okay, so please give us 7 days. After 3 minutes, so it is 8:35. From 8:38 onwards, we are going to start the bonus registration opportunity. So if you like this webinar, and in case you want to do the criminal drafting and proceedings course by Octopus Law School, it's a 2-month-long live course taught by Samiksha, and of course, it's been developed by 4 to 5 other equally good experts. Please stay back till 9:15 to get the bonus registration opportunity. Okay. In case you are not interested in doing the course, this webinar might be complete for you, and you can exit the webinar. Thanks a lot for attending, and I've disabled the chat because I didn't want too many disturbances, but let me enable the chat. Okay, yes. So if you are, for those of you who want the certificate, again, I'm discouraging you from doing that. Okay, you can go ahead. Link is not working. Okay. For some of you, the link is not open. Let me just check. Okay. Reba J and everyone. Aditi, okay, it's not working. It's surprising. Let me quickly check on this. Okay.
Tanuj, I think they can just copy this link and paste it on their browser, and hopefully it should work.
Okay, please, guys. So Samiksha is an expert in links also, not just check bounce. So copy the link, paste it on your browser, and see if it's working. Okay. All of the folks who are saying, okay, thank you, and Debajay and Aditi, welcome. Okay. Are you able to open the link, folks? Anyone who's able to open the link? Anyone? Yes. Okay, Meha, is it working? No. Yes. Some people are saying yes. Mostly it's not opening. Don't worry, folks. We'll be sending to you again. Okay, let me just share it again. Samiksha, are you able to open it? Can you? Okay,
I'm
you are.
able to open it also and able to copy it also. You just have to right click on the link to be able to copy it, guys, like we usually do for anything rather.
Okay, so I'm pasting it again. Maybe it will work. Okay, delete the semicolon on the link. Okay, that's a great spot there, Moses. Thank you
It's
for the.
working for me though, Tanuj.
Oh, not a problem. Not a problem. I think sometimes it does, links,
Yeah.
even if there's small changes here and there, they don't work. Okay, so please go ahead, Moses. Yes, thank you for coming to my rescue. As I'm getting old, I'm getting technically disempowered. And this is the code, folks. Okay. Is it working for you guys? Gaurav, we will be sharing the recording. Yes, definitely. We will be sharing the recording. Will also share the resources. Okay, the PPT with the yes, definitely will share the PPT over email and on the WhatsApp group as well. We have, I think, already shared with a lot of you. In case you haven't registered right towards the end, we have already done that. Okay, Vidas says, were to learn a lot. Thank you for organizing. And yeah, these things are usually not taught in classroom. Vidhi, don't worry about the WhatsApp group. Okay, we'll share all of this over email as well. Right. Link to the WhatsApp group, folks. I'm seriously saying that's not required. Okay. Okay. So, folks, let's wait till 8:40. I'll give you time to, download the certificate if you want. Not download it, actually, just pay for the certificate. The link or the e-certificate you will get in 7 working days. Okay. I'm going to stop the chat box for a while. Digvijay, thank you. Okay. Samiksha, feel free to take a bit of rest. I know you've been speaking a lot. It's a lot of investment of time and energy. Please feel free to take a 2-3 minute break. I will be here, and folks, Samiksha will return in 2-3 minutes to address your questions about the course as well.
Meanwhile, Tanuj, I was thinking I could answer some questions on the chat box also. So if the questions are like
yes, maybe
answerable.
just 1 or 2 questions, Samiksha, and
Sure.
I think then we will move to the registration opportunity. Yeah. Feel free, Samiksha.
Thank you, Tanuj.
Are there any specific questions you want to address?
I'm just looking, Tanuj, for questions that have shorter answers that is better, that could be
Sure.
explained in the chat box. I'll just address them.
Sure. Okay, so Samiksha, let's move ahead with the registration opportunity, and so folks, let me share my screen. Just a second. So folks, as discussed earlier, we'll now move ahead with the bonus registration opportunity. Okay. In case you are not interested in registering for the course, this webinar might be complete for you and you can exit the webinar. But trust me, this course has a lot of value for you. Whether you are a law student or a young lawyer, you must check this out.